welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode.
And friends, welcome back. We're once again with Callaway County Attorney Jeff Roberts. And today we're going to talk about when an employer is hesitant or actually refuses to file a workers' compensation claim if you've been injured in the workplace. Jeff, how you doing?
Doing good, Jim. How are you?
Buddy, I'm doing fine. This is, we've talked over the years about the games that are played, and it's unfortunate, especially when you've worked, years and years for an employer. You've given them the best years of your life in some instances. And then when you get hurt, you expect them to step up, but it's not always the way it works out, unfortunately.
Not always. There's times that you can run into trouble just getting the employer to do what they're supposed to do when you report a work-related injury.
Supposed to do it by law, actually, right?
Yes, by law. When you report an injury, by insurance contract, they're supposed to have notified their insurance company in that situation. And that's something that I've had a few people call up recently about this issue where they reported the injury to the employer and the employer didn't notify the insurance company in that case. And it's something that pops up periodically and has throughout my career over the last 33 years where this comes up periodically. And it's different things that occur. There are some are where the employer basically tries to say the injury didn't occur.
So deny it would happen at work. You did this over the weekend. Now you're trying to file a claim.
Exactly. They said, well, how do we know this happened at work? Nobody witnessed this incident, and so we don't think it actually happened here, so we're not going to notify our insurance company.
Right.
And that is something that does occur periodically from there. Thankfully, most employers go ahead and report it to the insurance company and let the insurance company do the investigation, which is what they should be doing. But some employers don't. And there's a couple of reasons for that, I think. One is they don't want the hit to their insurance and hope that the person doesn't pursue the claim further after that.
Basically, it's almost like you and I in a car wreck. If we file a claim, our rates may go up. So we're going to pull back on that. And maybe we'll try to fix it ourselves or do, take it and pay it out of pocket. That's what the company's thinking, right? That they may try to keep it in-house and not submit the claim.
Correct. Some of them do it. They don't want to notify their carrier of a potential claim for fear it's going to raise their rates. And so they never don't want to report it up the ladder or up to the insurance company. And that can does create problems for the injured worker because the workers' comp insurance company doesn't know about the claim, so they're not the ones paying the medical bills. And if either health insurance is paying and the injured worker's getting a copay or a deductible that they're having to pay out of pocket situation, and you do have the situation that you're talking about too, where the carrier or the employer will sometimes tell the worker. And I usually see this when they think it's just a very minor injury, and says, well, go to urgent care. We'll take care of the bill. We'll take care of any prescriptions. And they think it's, they go to urgent care, get a muscle relaxer. And, 2 weeks later, everything's fine. There's no more medical treatment.
Something. Yeah.
Exactly. And so they think that it will again save on their insurance rate. So they try to handle it that way. And then, 3 months later, when treatment's still going on and they're referring you for MRI, and then the employer says, we don't want to be paying for MRI or surgery or anything of that nature. And so they will frequently at that time go ahead and report it up to the insurance company. But then the insurance company's looking at the claims. Why wasn't this reported timely? Hopefully the employer will say, the injured worker told us timely, and we thought it was just going to be minor, so we dealt with it in-house. But I have had situations where they said, well, we just found out that this was work-related, even though they knew, beforehand that it was work related. And I've had some of the employee witnesses come back and say, yeah, he told me the day it happened.
Well, I could see a supervisor saying, well, maybe it's a strained muscle, again, a couple of days, but when that strained muscle actually turns out to be a herniated disc, now you're looking at surgery. That's a whole different game.
Correct.
And I think that's when all of a sudden the uh-oh moment happens.
Yes.
And, now the problems start.
Right. And depending on how the employer handles that, if the employer is, is honest about it and says, yeah, he told us initially, we've been dealing with it. We thought it's just going to be, an urgent care visit or a doctor's visit with one prescription. And so we took care of that in-house. We realize now that we shouldn't have done that. It's much bigger. And so now we're sending it up to you. Everything's generally fine there. The insurance company's beef is with the employer in that situation. If you have an employer that is not honest and tries to say that we didn't know about it, unless we can prove that they knew about it, that's something we have to find out in the case. But if that's the issue, then the insurance company very well may take the position, you didn't give due and timely notice, so we don't have to pay this case.
And we've talked about that in so many of these workers' compensation episodes that the injured worker has a duty to notify. You want to talk about that real briefly?
Yes. Yeah, so the Kentucky law says that you have to notify your employer as soon as practical after a work-related injury. That doesn't mean that you have to give notice immediately. Right. Some company policies say that you've got to give notice within 24 hours or it's not covered. That's not Kentucky law either, and that's not the case. I've had employers in the past take that position. I've never lost that in front of a judge yet. But if you wait 3 months, then we've got an issue. And in fact, I recently turned a potential case down for that very issue. Wow. It would have been 7 or 8 months after the injury, and when the person talked to me, and he had not notified the employer yet of the injury, and I told him that's too big. That's too long for me to be comfortable handling the case on a contingency basis. And so you've got that situation. You've got to give notice as soon as practical. There are some exceptions to that. So if you didn't give notice, talk to an attorney. There may be ways around that. But best thing to do is notify the employer. And you don't have to go up to HR. Your company may say that, and if that's what the company policy is, then go up to HR and tell them. If they got a plant nurses station, go report it to the plant nurses station. But you telling your immediate supervisor is sufficient.
That satisfies the requirement.
Yes, you give notice to the people above you in the chain of command. Telling your buddy that works on the same line with you across from you on the assembly line is not notice to the employer.
Right.
It's got to be somebody above you in the chain of command. From that standpoint, that is who you would report to.
So when an employer potentially turns it over after a while to the insurance company, they may say, well, we didn't find out about it. It opens up a can of worms because now the insurance company may start to question, well, is it truly work related? And now you're a little bit on defense trying to say, yes, we notified, we did this. This is how it happened, when it happened. Right. But it's a layer that you shouldn't have to go through.
Correct. That is an issue that you can go through, which is another reason why when you go to a doctor for a work-related injury, you've got to tell the doctor this occurred at work. This is what happened at work. This is why I'm injured. And you have to do that at your very, very first doctor's visit. If you wait till third or fourth doctor's visit, the first 2 or 3 don't mention it, and then say, oh, yeah, by the way, this occurred a month ago at work, we're going to have problems.
It looks like you're trying to game the system.
Correct.
Okay.
Yeah.
So you said when you go to your doctor, that could also be the urgent care, correct? I mean, whenever you go get medical treatment, get it on the record that this is work related. Yeah.
The first medical treatment you seek for the injury, you tell them. The second medical treatment, third, fourth, anytime you go to a different doctor, you've been referred to a new doctor, you tell that doctor at the first visit what happened. So you make sure you document it from that standpoint. And, if another layer there that you can protect yourself, especially if your employer says, well, we're going to cover the bills yourself to start with, is to protect yourself. If you've got your supervisor's cell phone or HR cell phone, send them a text message and say, this was our conversation today. You said you're not reporting it up. That's fine with me. You're going to cover the bills. I told you it's work related. You said go to urgent care, bring you back the bill. Y'all will take care of reimbursing me. That's fine if that's how you want to do it. But you've got documentation then that you have notified the employer. You've confirmed what that conversation is, and we would have a written documentation of that we can present to the judge if we have to do so.
It's a digital paper trail.
Correct.
That makes sense. So, if an employer decides, hey, look, we're going to wait on this, maybe they're concerned about their rates going up if they report the claim. The other issue is, in reality, maybe their coverage has lapsed. Maybe they don't have workers' compensation, a policy in place at that time, and that's a problem.
That's a problem. That's a huge problem for people. And you do have employers that do not have workers' comp insurance coverage in Kentucky. And frequently in that situation, what I see is the employer tries to claim that it is that you're not an employee.
Oh, that's interesting.
They do the misclassification aspect and claim that you're an independent contractor. You're not an employee, and so you're not covered by workers' comp. So we don't have workers' comp because we don't have an employee. We only hire independent contractors. And there are situations where you could be a true independent contractor, but I've seen a lot of situations where they tried to claim the person was an independent contractor and they aren't an independent contractor. And so there's a test that you look at, the economic realities test that you look at in Kentucky now that go through to make that determination on whether someone is or is not. And even if they don't have coverage, while it is a problem for the person, the injured worker has problems there is an avenue of recovery because Kentucky does have an uninsured employers fund, which is a fund that is set up. Every employer in Kentucky, when they pay insurance premiums, part of that premium goes to fund the workers' comp or the uninsured employers fund in that regard. And so this fund is there to cover injured workers when the employer does not have workers' comp insurance coverage. The problem for the worker is that fund does not pay until there's an administrative law judge orders directing them to pay in that situation. So while you're getting that treatment, you don't have workers' comp taking care of your medical bill. If you have health insurance, then we'll let health insurance take care of it and get them reimbursed at a later time. But that creates more difficulties for the injured worker in that situation.
I mean, ultimately, if the judge says, okay, we think this is, work related and we're going to get you, get the comp benefits rolling,
right,
you can submit those medical bills at that point, right? You're not on your own for those, are you?
Correct. If the claim is denied or there's no insurance company to submit the bills to, then that is a legitimate reason not to submit the bills. The workers' comp law does require bills to be timely submitted to an insurance company, and so if you have been injured and there is coverage and they've accepted the claim and are paying, then those bills have to be timely submitted. It's on the doctor to do that.
Yeah.
But if there is no carrier there to pay, there's nobody to submit bills to get paid in that situation. So that is a legitimate reason to not pay the bill or to not submit the bills within that 45-day time limit that the statute provides for.
And if an employee who's been hurt, on the job there, realizes, okay, look, the company evidently doesn't have workers' comp, and ultimately, okay, so now this fund is going to kick in and start picking it up. It's going to pay out the normal rates, right? I mean, you're not going to have any discounts or anything like that to worry about. You're going to get the standard workers' compensation rates.
Right. The uninsured employers fund pays out what the insurance company would have paid out. Mm-hmm. Again, not until you have to litigate the case.
Yeah, it takes a while.
It's a guaranteed litigation on those cases. But yes, they will pay out, and then they can pursue a claim against the employer that did not have insurance to recoup what they paid out.
Right.
There's another quirk when the employer does not have workers' comp coverage that people need to be aware of, and that is that's considered a waiver of the exclusive remedy provision of the Workers' Comp Act. And while you do not have to establish negligence in a workers' compensation claim to get workers' comp benefits, if the employer is negligent and they don't have comp coverage, then you can pursue a workers' comp claim against them in the uninsured employers fund, but you can also sue them in civil court to get pain and suffering. That's about the only time you see the exclusive remedy truly be waived in Kentucky is in that situation. And I've pursued that type of claim a few different times in your insured employers.
And friends, we've talked about various topics that we've actually addressed in previous episodes. So if you go through the show notes, this is the transcript and everything of the actual conversation today, you'll see links to those episodes. So if you want to learn a little bit more about, in fact, we did a specific episode on what happens if my employer doesn't have workers' comp insurance. There'll be a link there that'll take you actually to that episode. So there's a lot of great resources there along with this. So if you're on Jeff's website, jeffrobertslaw.com, make sure that when you open up, the podcast to look at it or to listen to it, that you look at those show notes. There's some great resources there.
Right.
Yeah. So, okay. So we've talked about maybe the employer was balking because the company didn't have a policy. Now the insurance company finally has it. It's been submitted. They're working on it. Now they're questioning, well, it was kind of late. Maybe this wasn't work related. It would be another issue. We're kind of going through the evolution of things that could happen. Now, a lot of other things could probably happen, but that's kind of the stair step that we've been taking at this point.
Yeah. Well, another situation is, that we have is, when the employer does cover, you go to the doctor, they actually pay the bills. And what you don't realize is, they pay your salary while you're off work if you take off work from that situation. Well, if the insurance company had been notified, you would get a letter from the Department of Workers' Claims eventually that says, your income benefits we've been notified your income benefits have been terminated on this date. You have 2 years from that date within which to file the claim form, or the statute of limitations may expire. And the Department of Workers' Claims sends that out to notify people of the statute of limitations. And if it's handled in-house, the employer does salary continuation, takes care of medical bills. You never get that letter, and most people don't know anything about a statute of limitations. So
specifically, what is it? We've talked about it. In fact, we talked about it in the previous episode as well.
Correct.
But for someone who's just now tuning in, briefly, what is a statute of limitations?
A statute of limitations is a law in Kentucky, and every other state has them as well. But it says you've got a certain deadline within which to file the claim. A car wreck has a certain statute of limitations. A workers' compensation claim has a certain statute of limitations. That statute varies according to the type of claim it is. If it's an injury claim, it's one. If it's occupational disease claim, it's something different. And so hearing loss is different. So it depends on what type of claim it is, on what the statute of limitations that is going to govern your case.
So it's a ticking clock.
Yes.
That's going on, and you have to have your claim filed within that proper time frame, that statute of limitations, to actually be able to pursue it.
Correct. Normally, for a work-related injury, it's 2 years from the date of injury or from the last payment of the temporary total disability benefits, is what the statute is for an injury. And so, but that, and that's the reason when they cut off that workers' comp income check to you when you go back to work, if you've been off work, the department sends that letter out then, because that's what that triggers the 2 years starting to run then.
Yep.
If you don't get income benefits, then the 2 years starts to run on the date that the injury occurred. If the employer does salary continuation, that's not considered the workers' comp income benefits, and that doesn't total it. So it's 2 years for the date of injury.
Well, and I think that would confuse a lot of people. I'm assuming, hey, I'm hurt, I'm not working, but I'm still getting paid, and so my medical bills are getting picked up. It still doesn't mean the claim has actually been filed.
Correct.
Is it? So you may be thinking, hey, I'm getting workers' comp.
Well,
in reality, you are, but you aren't.
Yeah, and it's filing of the claim forms with the Department of Workers' Claims.
Yep.
So a lot of people think, well, I filed the claim with the insurance company. It's not filing the claim with the insurance company. It's filing it with the Department of Workers' Claims to get it in front of an administrative law judge. It's getting the legal process started, not the insurance claim started, the legal process.
That's where I always get tripped up when we're talking about it. It's like,
Right.
wait a minute, they are two different things.
They are.
And that's really that's the responsibility of the attorney usually, right? Unless you're going to represent yourself. But, typically the attorney's going to file that form on time within the statute so that you can, pursue that.
Yes, absolutely. Or at least they should be.
Yeah, it should be. It should be. Yeah. Wow. Unbelievable. So realistically, the attorney, the employer could also just be trying to run out the clock.
Could be trying to run out the clock from that standpoint. Sometimes they will do that. I've had employers who will tell the injured worker, we're going to take care of it. We're going to protect you. And then clock runs out, find out that the injury is great, that they're going to have more treatment for it.
Yeah.
And that occurs at times. People don't realize that, but you could suffer an injury at work, lifting a heavy box at work and have a low back injury from that and, get a little treatment initially, have potentially have a herniated disc, but it's not pinching a nerve yet. And so you are able to go back to work, but then it progresses over time, which some injuries do. And then 3 years later, doctor says, well, this has progressed to the point you need surgery now, and it's all related back to that work injury you had. Well, if you had been pursuing the workers' comp claim, through the way the process was, you would have locked in your future medical treatment when you resolved the case. From there, if the carrier or if the employer covered it, you never got that letter, never thought to ask anybody, and now not only have you lost your claim for income benefits, but you've lost your right to future medical treatment.
Wow. And all of this because you trusted the employer to do it right.
Well,
and some do, but in any group, there's always that one or two.
Correct. And sometimes the employer doesn't intend for the person to lose their claim, but they don't know the law either.
Yep.
And so they're doing, they think, okay, this is saving my premium going up. I'll pay this $1,000 in medical bills, and keep my premiums from going up for the next several years, not realizing what the injured worker may be giving up.
Yeah. Well, I can remember this little kid running through the house and knocked over a lamp. I said, Mom, I didn't mean to break the lamp. Dad quickly pointed out it's still broken.
It's still broken.
And so, again, the employer may not have thought about messing up your right to to workers' comp claim, but you're still in a bad spot.
You're still in a bad spot, and it's the injured worker who is bearing the brunt of that because the injured worker then is the one who's not going to get paid when they're off work for that surgery that they need. Going to be paying co-pays and deductibles if they have health insurance. Be paying co-pays and deductibles for that surgery. If they don't have health insurance, may not be getting that surgery that day.
Right.
I won't be getting that.
Well, as you said, there could be follow-on surgeries. I mean, we're gonna address this. We're gonna see how it goes. You need to have maybe a month or two to recuperate, and let's see how you're feeling. And maybe we have to go back in and do something else. There's all these different situations that come up. And again, it should have been covered the proper way from the outset, but unfortunately, it just doesn't always happen.
No, it doesn't always happen. Unfortunately, some employers don't follow that proper procedure there, and when they don't, it can come back.
And you said at the outset, I mean, you've handled a number of these cases.
Yes.
I mean, this is not just theory; this is reality.
I've handled a number of these cases, and I've had clients in the office, potential clients in the office, to talk to me about their case where I had to tell them, I'm sorry, but your statute of limitations is already run on this case. And I know the employer said they want to take care of you. That doesn't protect you.
Yeah, that's horrible. Jeff, if somebody's been listening to this and they want to get in touch with you, maybe they have a concern about, well, I think I'm getting workers' comp. I'm not sure. Or, hey, I was hurt on the job. I've just got some questions about my rights. You offer a free initial consultation, right?
Yes, I do offer free initial consultations in certain cases. The initial consultation never costs you call up and the statute of limitations is blown, I'll tell you that over the phone. I'm not going to have an in-person meeting with you in that situation. So just calling the office doesn't get you a free initial consultation. But when I sit down and talk with people, it is the first consultation is free. If you don't hire me in the case, you won't get a bill from me for that consultation. If you do hire me, you won't get a bill for that consultation. I work on a contingency fee basis, which we've talked about before. But that means I get paid at the end. My fee is contingent upon the recovery, and the better I do for you, the better I do for myself. But it's a percentage of the recovery. You're not out of pocket anything. When you hire me, I get paid at the end. When I put money in your pocket is when I get paid as well.
Yeah. And I think that's interesting for a lot of people who have not dealt with this kind of claim. They don't know. I mean, maybe they think they've got to pay a retainer or pay an hourly fee, and it just doesn't work like that. It doesn't. That's not how it works in workers' comp. That's not how it works in personal injury with a car wreck, which you handle a ton of car wreck cases.
Correct. Yes, I've had a lot of people who, when they call, ask what's the cost to come in to talk to Mr. Roberts for a consultation, and a lot of times they are surprised to learn that they get to come in and talk to me free initially, and even when they hire me in the case, they don't have to pay me any money at the time of hiring. My fee agreement, my initial retainer or agreement where you hire me, it is called a retainer agreement, and I have to explain to people at times that this is you're retaining me by signing this. You're retaining me to represent you in this case. The Kentucky Bar Association requires I have a signed agreement with you.
Yep.
If it's going to be contingency fee, I have to have that signed by you in writing, where you're retaining me on the case. I can't do anything until you do that. But it's just called a retainer agreement because you're retaining me. You're not paying me a retainer fee.
Right. And so during a case like this, it's going to take a while. Workers' compensation typically takes a while to get through the system. And there could be hearings, there could be motions that go on, there could be ultimately you may actually get to your in-person hearing with the administrative law judge. But during that time, you may be doing depositions, you may be ordering records, obviously, you may be incurring a lot of different expenses. You're fronting all of that court cost, that case expenses. You're fronting that. That's not coming out of the client's pocket along the way. Again, it's not until the very end when you secure, some type of settlement, some type of award. At that point, you guys will settle up, but it's not like they have to pay along the way.
Right. They don't have to pay along the way. I advance the litigation expenses again like that, and they are contingent upon recovery. Yeah. So if we are successful, I'll get paid the attorney fee and reimburse my expenses. If we're not successful, you don't owe me a penny for my services. You don't owe me reimbursement of my expenses. I write that. I don't. Unfortunately, I'm not allowed to write it off, but from a tax standpoint, but I eat that loss.
Yeah.
From that situation. So.
And I think again, not realizing that there's not an upfront fee to hire Jeff, but also the fact that if you're not successful in the claim, you're not sending him a bill either. I think that's another aspect of this. That again, your motto, for the office talks about how you want to treat a customer.
Correct.
A client in this case.
Yeah. My office motto, what we try to live up to in every case that we handle, every client that we have, is that we try to provide small town service and deliver big city results for our clients. I try to keep my clients informed of what's going on. Matter of fact, I usually try to let my clients know what's going to be coming up.
Yeah.
Because if you know something's coming up, and then it happens, you don't have as much anxiety and stress over it because you knew that was going to happen. So security claim, I tell the clients when I'm hired, if I'm hired after the initial denial, is that we're going to file a request for reconsideration, and most likely in about 3 or 4 months, you're going to get a second denial. And don't get upset that you get a second denial. It's the road you got to take to get on disability. And when they know that, they don't get, when they get it in, they call it up and say, you were right. I got the denial letter again, and then we go forward with it from that standpoint. So that's kind of part of the small town service that I try to provide for my clients. You're not just a number in my office, and that's, to me, I think that's the way I would want to be treated, and that's the way I try to treat other people.
No, and I think your Google reviews bear that out. I mean, if you go out and you Google Robert's Law Office Murray, you're going to see just a ton of comments and 5-star reviews from your clients, and I think that validates exactly what you said. They always talk about the way you treat them, the communication, they talk about the results, but a lot of times it's that experience that they talk about, and it's really just fantastic to hear.
Yeah.
So you said that the person is not a number. However, you do have a number for the law firm.
You do have a phone number.
You've got two offices. You've got your primary office there in Callaway County in Murray, and then you've got another one in Christian County over in Hopkinsville, right?
Right. I do have an office in Hopkinsville and in Murray, but just the one phone number. The phone number to reach me is 270-753-0053. You call that number during regular business hours. You should get a live person to answer that phone for you. If I can talk to you, I'll talk to you. If I'm not available, talk to you at that time. They'll get me the message, and we'll try to take care of it.
Outstanding. So, Jeff, again, I guess as we're closing up the episode, as we're wrapping up, if you're out there and you've had a workplace injury and your employer is kind of balking a little bit, or they're trying to make something that feels just a little off, you might want to get an attorney involved. You might want to ask for some advice. Hey, does this seem legit? Should I be worried? And just ready to take that call. And it really just kind of, okay, let's talk about your specific situation, because it's going to be different from other people's situations.
Exactly. Every case is its own case. It's on its own facts from that situation. And just one little bitty difference in the fact pattern may make a huge difference on whether you can or cannot pursue that case. So,
absolutely.
Yeah.
Well, friends, this is our second video podcast episode. We've done a lot of podcast episodes, but this is our second video. We hope you've enjoyed it. We're going to be able to take some of the outtakes from this and publish that out on social media as well. Hopefully you like this. We'd like to hear, hey, do you prefer this video format versus the strict audio format? You'll still have that available, obviously, but we'd love to hear from you as far as, hey, how do you like this? Do you think this is an interesting way to present this information?
Right.
So we'll be back in a couple of weeks, but thanks for tuning in with us. Thanks for sticking with us on this one. And Jeff, as always, thanks for your time. I really appreciate it.
Thank you. Thank you for listening and watching.
Absolutely. Take care. Bye-bye.
Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.